more to say, but I will limit myself to something that it makes sense. What Thomas said is correct. Wilson said that I spoke to him that somebody needs to look into this. I first came across this act, which I found that first reading of it when I was revenue secretary. At the time when the mutation to individual flat owners issue came up. So that's then itself I found that this law is not drafted well, not being seen by anybody for that. Luckily, after a year or so of that incident, I became chairman of the Ministry. The first 3 months itself, I wrote to the government to need of amending this law, the apartment ownership law, because that is not in conformity with the central. So I wanted actually Johnson to declare, High Court to declare certain sections of the apartment ownership laws unconstitutional. It was not in conformity with the central. That should have been a better thing, I remember now, I believe now. Some sections unconstitutional means government would have opened up making more faster than giving them direction that you consider all this. I mean, maybe not the same, but some of the provisions are actually, in my opinion, unconstitutional because it's against the central. So that is the legal background of this. So I think in January or February 2020, I wrote to government on need of amending this, citing a few days, but in overall it has to be done. Now, the agreement which was part of our rule, the central model agreement they have sent to the states is simply copied from that without looking at what our apartment ownership act says. So that was one reason by which the law says that it has to be in accordance with the apartment ownership. But apartment ownership passes only for apartment. The revenue has to be drafted for villas, plots, commercial, everything is involved in that. The same agreement is for everybody. So that is one reason by which one of the first demand I made to the government is to change the name of the apartment, the definition into only things come under this law, because that's all the matters are saying. Instead of apartment ownership act, it will say apartment definition you change into villas, including commercial buildings, and everything comes under the same law. So that was one demand which I made, because how do you enter into an agreement for a commercial complex under the apartment ownership act? Because apartment ownership act doesn't speak about information constructions, shopping complex, etc. Especially IT, a lot of office complex and so many projects will come, but you really have to prepare. Kerala is actually organized real estate very small. That is one reason the government is not very serious about this matter. The number of people affected, you know how much it will be? Less than 1 lakh. We have the highest number of units registered is 9,300 last year. So on an average, it was only a 5,000 apartment for the last 20 years. 5,000, 4,000, 6,000. After the Rana law came, people have more credibility, and of course the economy is growing. Now it has gone to 9,300 apartments in India. One district alone has a RERA in Haryana. They have, and ours is something like 6,000 to 7,000 crores of investment in India. Gurgaon alone has something like 1 lakh crore of investment every year. That is some action. Noida has 1.5 lakh crore of investment every year coming. And Kerala around 6,000, 7,000. It's the size what we have. So that is the number in democracy, number market. So whatever you say, I remember there was a discussion here where highly aided MB and MLA Umar Thomas about it. Highly aided first says that apartment owners, please take your voters list into this. You are not a voter in the apartment. He said for Umar Thomas election, we went to various flats and found that only 510 are in the electoral list. Rest are all having votes outside. So he said, if you want to be heard, be our voter. This is the type of politics which has come now. They're not for public purpose, they are only for voters' purpose. If you are not a voter, I don't find any solution for this. I told him, you are giving my sons, don't be into such a politics. You know, such an educated man should never say that. And the village should keep public interest. not his voters' interest for MLA. This is the way the subject is not much. Now that more and more are coming, more of commercial constructions, villas, all are coming into this fold. The number of people are affected more and more. So it is high time that the artists, like Johnson said, this provision of submitting a declaration is not basically in the Indian jurisprudence. It is not required. We make the property and lastly say that this law is applicable to you or parliament. It is with the Condominium Act of California. The American jurisprudence only maybe private property for them it is more important. So if I want to submit my private property to law, I have to give a declaration. It was the most unnecessary thing. I believe that the new draft which is being made has removed that section. This submitting. Because central law doesn't require such a thing. Central law made all this applicable to you whether you submit or not. So that way, that is not most important. All the complication came here only because of declaration. Johnson first went to the Chuttam case and all that because of declaration. Because it was compulsory on the builder to give a declaration, he will do so. It compulsory of every flat owner to file a declaration which requires law to brokers. And then I think before 10-15 years there was no mention of an authority to whom it has to be declared. Later they said it is the district registrar. So district registrar office, if all these people, tons of declarations will come. All this impracticality has never seen, nobody has looked at this act. Now that it has come to the legal thing and a lot of demand has come, draft demand. And that draft is now running, I was told, that one of the biggest things in Kerala's lawmaking, Central is much better than that, is that they create a government enacts a law, they bring it to the cabinet and clear it for placing in this thing. There are the governments are available for change account. So a prior consultation is very important. My first only point is that the Society of Construction Law, the Flat Owners Association, they want to immediately move to Mr. Rajesh and the Law Minister, Mr. Rajiv, to have a consultation, a one-day workshop or a thing before this draft is finalized. Remember the thing is, once the draft is finalized, they are not at all available. These are drafted by people who are secretariat-centered guys who has very little practical experience. So what we need to do is, the first suggestion that I have is, you should resort today that you should move the Law Minister and the Mr. Rajesh. But actually, this subject is the apartment ownership act is under the administrative department, revenue, housing. The housing minister is the one right now. In my letter to government, I moved that the administrative department of this act has to be moved to LSC because they control the RERA. So all the construction, everything is controlled. I also moved that the administrative department has to be changed from housing. Housing department doesn't know this. So this is that service also you should make. It has to be one ministry, so that they are a direct affected ministry. This is basically LSC, Panchayat and all that. So the subject has to be LSC in Kerala scenario. That will also help. So these two demands you should make. Then the agreement, I think I'm not criticizing Johnson. You should have made the LSC secretary as a party, and LSC secretary is only one who can enforce the agreement. Enforcing the agreement if somebody has done it wrongly, it is for the RERA to actually punish them. Housing secretary is nothing to do. Unfortunately, High Court has directed the housing secretary to ensure this. He has nothing to do with this. Mr. The housing secretary will act on it. LSC secretary will LSC secretary RERA secretary can demand you enforce that agreement. Now, ഞങ്ങളതിന് മറുപടി കൊടുത്തിരുന്നു ഈ അപ്പാർട്ട്മെന്റ് അപ്പാർട്ട്മെന്റ് മാത്രമല്ല എല്ലാം ഉണ്ട് കൊമേഴ്ഷ്യൽ ഉണ്ട് ആയിക്കോട്ടെ കൊടുത്തിരുന്നു. What will be clear only when this is done? Now in Orissa, this given the issue, somebody moved High Court saying that the common amenities which includes the project land in food has to be transferred to the society. They were giving this individual share, the undivided share. High Court, Orissa High Court stayed directed the registrar not to make any such registration. So the registration of flats became still there. And the High Court appointed a committee of RERA, government and all that to come with a new law. So they enacted the new law in November or December last year. And our law is he told with that thing, but not all the parts of it is not there. I didn't see a draft, it is only because there are secretary or a member, I spoke to her, and she says that almost in Orissa line is being drafted, minus the redevelopment. Orissa law also mentioned about the law for redeveloping a old flat into a new flat, which in Maharashtra is under a law now. I think other some few states are also done. That is also made a part of the apartment ownership party in Orissa. I think we should demand that also. That is one big application the buyers have. Now 50, 60 years when it becomes need to be demolished and reconstructed, where is our right to it? That right also has to be now defined in the law. And this law can define that, how that redevelopment has to happen. So that these two, when it comes, it becomes very much all right about that. And from my experience, I think some of the lawyers also must be facing this, and people will be coming to cases with you, is the multiplicity of associations. Neither the Apartment Ownership Act or the RERA Act allows more than one society. And Kerala being a very big multi-polar society, the tendency to make more societies. And the society is registered under Society Registration Act 1860, which is also applicable in Kerala. There, for the same purpose, only one society can be registered. In our Travancore literacy, there is no such provision. Is what I may be wrong. I believe that is. So two societies can be registered for the same apartment. Two association can be registered. Without it bad. Same purpose too. I think there's some measure in that thing. Same purpose to society cannot be done. But that is the reason by which multiple registered societies are there too. So that means people are not able to join together for a peaceful living, as a community living. That is a thing which way, these are a psychological thing, but law, of course, is a basis for people to come together. If you want to see the law, people will be forced to come together. Now, in the future, now the new projects which are coming, they are not forming association. Look at the nature of the Malayalis. They say we will only have an owners association, not annuities association. Annuity become an owner once it is registered in his name. So I told many people saying that you can convert the name from the annuity organization to the annuity association, the owners association, once the ownership is transferred to you. They said, no, owner is prestigious word. Annuity means some to type. So I don't want to. So they don't want to form an association. Now that law is a very central part of an annuity association. After 50% of the sale is done, the promoter is supposed to facilitate that association. There is a lot of meaning in that. That association can interact with them, and they also see that the plants are not violated. Instead of an individual allotee going and looking how the construction is going, that association, some interested members can really have a look at this, and if the promoter is violating the plan or any happy parliament is there, they can come to RERA and file a case. So a lot of meaning is there in having that association. There are very few promoters. They won't write to me saying that we have returned to all the allotees till 60%. They write back that we are not interested in forming any association. We only have owners association. This is the type of situation. All these things has to change in Kerala. The essentials of law has to be understood by you. We are a very literate society, but we have our own idiosyncrasies, which doesn't allow us to follow law exactly as it is directed by the parliament or directed by the parliament. These are so many issues. So I would suggest you that you move these two legislators, have a meeting, and see that the draft wherever it comes. And delay also we have to avoid. Because more and more flats are coming is going to be a very big issue. And they are going to make a committee authority some town planning commission again. The committee authority, I have suggested a committee authority, one town planner is sitting in RERA. He is the best suitable person to have that committee authority. Very little work he has. A senior officer, RERA can manage it very well electronically or sort of digitally, everything can be done. Now that this declaration is not required. Society registration can be done simply because everything comes to RERA, we have every data. Society can be simply registered once the name of the people comes. Society can automatically registered under the apartment ownership. So it has been a very, very easy process. So you should find that now that for future. Now what Johnson was saying that what will happen to the Pre-RERA case. Pre-RERA case look like the same thing today in the law. For pre-RERA cases also, this is the same thing. RERA case, of course, association is illegal. So you adopt that to that law. For pre-RERA cases, the same way the association can be registered. You can do something like that in the law. For previous things also, can make with retrospective effect, you make that all the non-RERA projects which have already happened, the same way society can be registered. Then also mentioned that who is the competent authority to resolve dispute between the allocates. That is the biggest thing which is now happening. Some allocates Kerala has a very specific problem because a lot of people don't stay there. They get it every and they don't contribute to the common charges. That is the thing which needs to be addressed. The present act says that the competent authority can create charge on a allocate or a homeowner. But check what charge I don't know. The word is charge. Once you remember, you must be remembering that. So there is something that he can create a charge on the apartment if there is any due. But it is again unclear, either in the act or rule, what is that due on which he can create charge. It's very unclear. So such a unclear law existed in Kerala statute book for so much time itself is a wonderful. We are very famous lawmakers, revolutionary law, Kerala Assembly having done such a law, remained on the statute without the needed amendment for so long. All our law reform commission, nobody bothered because nobody approaches them. Very little blindly is there. That is why nobody approached. Now I am seeing this as an issue on the association. There is a federation of associations and all that has come. So in the right time, it is the iron is hot now, you need to strike. Please do this. You deliberate on all this. Unfortunately, the draft is not made public. I also made it. My own secretary, who is a member, she refuses to give me a copy. So had a copy with that, I will give it to you, so you should have. So you demand a copy of the draft, either demand a copy of the draft, or you make a discussion on requirements which will get into the draft. So this is what I basically want to say. I maybe, I don't know, the notification has come out. If the notification has come out, I am not being here. That's it. If the notification is coming only on Monday, till that time, I'm a Lala chair. It was a really great opportunity in life for me to look into a different way than my service. It's a very different subject which I never dealt with otherwise. To go to that subject, I enjoy doing this. Established an office, established some fundamentals of this, but it has a long way to go. I don't think we have done all that is required, especially last 1 year because I'm on a daily type of thing. I didn't take so much of new initiatives to issue common orders, further streamlining the procedure and all that. The authority can do. We can make new regulations. I plan to make new regulations, which make things more transparent and like this agreement signing without a clause. I issued so many audits, they are violating those audits. The act and my directions, all they are violating by removing this. Now, one of the biggest case now coming before us in the ongoing projects, our projects which are completed with the common fund collected. What is that called? The corpus fund is a requirement, I believe. The RERA Act do not expressly allow or disallow that. So I said that the corpus fund collection has to be a mutually agreed thing after the formal format or 33 clauses in the agreement, as a 34th, 35th clauses, they can keep mutually agreed clauses. So there are associations now which has 6 to 7 crores of money. 6 to 7 crores of money. When there is a 450 apartments, somebody collected 50,000, 1 lakh each for corpus fund. Huge money alone, which interest for last 10 years. And the fight basically is on who controls that money now. So these are the things which one, how do we solve it? In an ongoing thing, we are able to, because it's a part of the agreement. We are able to say the money be given back or given to the association. And there are good businessmen who have deposited in a separate account and interest is accruing to that. There are some people who utilize that money and he will say, I will pay without interest after 10 years. See, that is not there in the agreement. Buyers actually what? They never look at the agreement. These long agreement. Nobody will look at the agreement and sign. And rarely they seek any legal advice. And the agreement that I'm signing, please with it and you but nobody does. So the person who is sitting in the UK or something, sorry, Gulf or something, these promoters will go and get it signed from him. He will just sign it and bring it back. He doesn't even come here. So Malayali has a very separate law. And they say, why did you leave the whole money in the beginning? So then one fellow says, I have money. He asked for it in my NRI account. There was money. I just wrote a check in Dubai. India. Now the flight is not done. Consumer also has to be questions. Yeah.
Sir, even cases that corpus money is completely finished by the builder and handing over 60,000 where they are collected.
No, there are cases. But in the postal era cases, if it is a part of the agreement, then we can enforce it.
So
Even otherwise, when both sides are agreed that money has to be collected, in our era registered case, we can order that the money be paid back with interest. Because with interest, we can order it. If it is a RERA registered. I'm only talking more about the older cases. Older cases, which is pre-RERA cases also, crores of people are lying in this account, and bigger businessmen have created a separate account and remained there. And all the interest is also has been accrued to them. So these are the things also should come into this one. So the relation between the association and its members has to better come in this law and don't leave it some sort of a how to collect money from them. And this has to be defined. Present law also says that he has to contribute proportionate to this area and all that is there. Now the contribution, if he doesn't done, what do they do? Now there are people who are coming and asking me, I said, I can't do it. They say, in their clause, if there is a situation like this in their society, in registration bylaw, then they will go for arbitration. So somebody has to pay 20,000 rupees and going for an arbitration is a worth thing. So that faster solution for everything is available in the RERA law and the connected law for the Department of Legislation. Those things also have to be defined. I'm sure that you will define that. So every law which is coming, at least for our state, make it totally meaningful, flawless, and prior consultation that we should ask for. Maybe when you get a situation like this, I can also come and strongly demand for these things with my experience of 5 years. I can work with the notion of new question for all these issues. Thank you very much for pulling me and saying some good words about me and not doing words. Thank you very much. I will go out now. So you continue. Thank you.